All right, well, let's call the first case.
First case is A17A1208 Heather Pollard as Executor v. Rockdale Hospital.
May it please the court. Good morning, Your Honors. My name is Darren Penn, and I am honored to be here on behalf of Heather Aller and David Nobles, the daughter and husband of Shirley Nobles, who unfortunately passed away while a patient at a hospital, Rockdale Medical Center, in June of 2010. The issue before this court today is, well, before I begin my argument, I would like to reserve 3 minutes towards the end. Thank you. The issue before the court today is an issue of paramount importance in medical malpractice cases, particularly in cases that allege vicarious liability against medical institutions. The trial court order in this case unfortunately erred in essentially holding that if a plaintiff is going to bring a medical malpractice case in the state of Georgia, their original pleadings, including their affidavit, must identify each and every negligent actor that they're relying upon for the vicarious liability claim.
Can't those just be amended?
Absolutely, Your Honor, and that's literally the point of the appellants in this case. And I think what may help us is I wanted to walk through the pleadings in this case, the applicable pleadings in this case, because in the briefing there's been a lot of back and forth about the statute of limitations, and in reality, in this particular case, there's only one affidavit that has anything to do with being filed outside of the statute of limitations. So if we begin with the renewal complaint, Your Honor, that was filed within the statute of limitations. In count one, in fact, I'm going to go through these counts very quickly, but in count one, it's entitled Medical Negligence of Rockdale and 24 On. Appellee 24 On is the defendant at issue in this case. So there's a specific count in this complaint filed within the statute of limitations pointing out negligence of 24 On. In paragraph 61, 62, and 63, it clearly identifies the conduct of 24 On by and through its physicians. So it's clearly identifying a vicarious liability claim based on physicians, not particularly identified physicians, but physicians within the practice group. And then you have...
Counsel, do you think, I didn't mean to interrupt, but do you think if you had done nothing more than said at the pleading stage on the complaint, if you had just said, if you hadn't mentioned anybody, if you had just said any treating physicians, respondent superior, would that, and then you later, because of discovery, went and amended your complaint, would that be good enough under your theory?
Absolutely, Your Honor. I think it absolutely, under Georgia law, particularly the definition of medical malpractice, which is codified in 9370, which it provides 2 different categories to define what a medical malpractice action is. One is against the individual practitioner, and of course I'm paraphrasing here. And then the second category under the definition of medical malpractice is any institution or corporation like 24 On, the appellee and defendant in this case.
It was named.
Right, and the language is broad, and it's very, it covers the claim against the entity and any of its employees or agents. It doesn't say any particular employees or agents. It doesn't say any specific employees or agents. So yes, very much it's the appellant's position, Your Honor, that you could simply file a medical malpractice case. We could have filed this case named no one but 24 On, alleged that they were vicariously liable for their physicians and their employees and their agents,
right,
and that would have sufficed. And then the affidavit could have said exactly the same thing in supporting that complaint.
The 9.1 affidavit would have had to at least generically refer to physicians, that physicians didn't do something or that they did do something that was negligent.
I agree with you, Your Honor. That is correct. Under actually, there's a number of cases that that talk about 9.1 affidavits, particularly the Supreme Court's decision in Gadd, and I think Hewitt is one as well, which say they actually hold you don't have to be specific and actually specifically name the negligent actor. All you have to do is link up the negligent act with a defendant in the case.
Does the appellee, from your understanding, agree that if you had named no specific person as the actor, as the physician, that your case would still be good? I mean, is that something that's conceded?
I do not think it is, Your Honor. By my read of the briefing, and particularly the amicus briefs that were filed on behalf of Emory and MAG as well, I think they dispute that. I think the position has been taken very clearly that under Georgia law, a plaintiff would have to specifically identify all of the negligence.
But you're not seeking to sue this other doctor individually. You're just saying this is, my understanding of your argument is you're saying this is, they're responsible for this doctor's actions under this respondent's, vicarious liability of 24 on. They're responsible, but I'm still, on that doctor, you're still suing 24 on, whereas you're also individually suing some of these other doctors that are specifically named. Is that right, or am I missing that?
You're exactly right, Your Honor.
Okay.
That's exactly what we're alleging, and in fact, we can take it even a step further and state that our position is that under our law, under 911, 9.1, 9370, 93130, which allows the amendments or treats affidavits just like any other pleading, and then 91115, which allows the liberal and free amendment of pleadings, just like affidavits, we could take it a step further and say we could have filed suit against 24 on and actually identified Dr. Hunt or Dr. Mitchell or both of them, relied on their negligence as the basis of the vicarious liability, and then turn around later at trial and talk about an entirely different employee as long as they are an employee of 24 on. That would still be proper.
Because the 9.1 requirement is just a threshold. It's just almost like a gatekeeper to make sure that there's some viability to a claim before it begins.
Yes, Your Honor, that is true. The 911 9.1, the purpose of it is to reduce the filing of frivolous lawsuits. And you're exactly right. It's an initial threshold pleading requirement. It's not a requirement to set forth a prima facie case. That comes much further down the line. And in the reality of the medical malpractice world, especially if you're filing a lawsuit against a large entity like a hospital or some other facility, you simply don't know who all is employed by who all at the time that you initiate the action.
Well, that's my concern. Are we going to get to the point where we're going to start saying physician John Doe number 1, physician John Doe number 2, up through number X, and then use 91121 and 91115, amend parties, drop, add? Isn't that where we're going?
Yes, Your Honor. That's exactly the problem that would be created by construing these statutes in this way, and that is a plaintiff would suddenly be forced to look up, all right, who are all the employees for this hospital that we're about to sue. Let's identify each and every one of these employees, put them in the affidavit, just so we're covered in case something happens in discovery and there's some employee that we didn't really know about ended up having something to do with the case. And in addition to that, if you take the reasoning of the Appellee's arguments and you move it forward, in this particular case, here's what could happen. If the appellants are not allowed to proceed with arguments that 24 on is vicariously liable for the actions of Dr. Syed, literally 24 on could turn around at trial and they could provide the proper notice pursuant to the statute and apportion blame to their own employee who the court has ruled you can't argue about. You can't point the blame at because of this statute of limitation issue. That would be an absurd result. And that's not at all what was intended by the law.
What about Thomas? If I understand your brief, you don't believe Thomas applies to this case, but in the amicus brief filed by GTLA, counsel that filed that brief actually encourages the court to overrule. So I don't think those positions are inconsistent, but tell me what your views are on Thomas, and do you agree with the amicus brief that we ought to overrule Thomas?
Your Honor, I do agree with the GTLA amicus brief that Thomas should be overruled. I think it was described as an outlier in that brief, and I agree. I think if you look at all the cases that are construing these statutes in medical malpractice situations, it is an outlier. And the reason I say that is because in the facts of that case, initially the case was brought against the physician as an employee of the medical center. And then later, they amended the complaint and tried to add claims against the nurses. If you just take those facts as both the doctor and the nurses were employees of the medical center, I believe under 9370, the claims are valid because they're agents and employees of the entity under subsection 2. Therefore, the case should have been able to be amended. However, the court doesn't need to go that far in this particular case. And the reason is because in Thomas versus the medical center case, I understand the logic and the reasoning of the court, and that is you're adding a new profession, you're adding a claim against a different type
They're
of
adding
medical
new claims, right?
profession.
And you're saying we're not really adding a new
Exactly.
claim, we're really expanding a claim that we already reserved.
Exactly. As just as Porquez versus Washington stated, a plaintiff is allowed to amend their affidavit to add additional deviations from the standard of care. And that's exactly what we were doing here. We're talking about 3 hospitalists. They're all the same profession, all the same facts apply, all the same issues in the underlying case apply, and that's all we were doing. We were just adding additional deviations from the standard of care.
Do you want to reserve the balance of your time, counsel?
I would, Your Honor.
Okay.
Thank you.
All right. We'll hear from the appellee.
Good morning.
Morning.
May it please the court, my name is Melissa Reading, and I represent Dr. Hunt and his employer, 24-on physician. An affidavit is required to bring a claim against a professional challenging his judgment, and you can't avoid it by naming the corporate employer. The plaintiffs asserted no claims about Dr. Syed or his care of Ms. Nobles until well after the time for bringing the claims ran. They never pled any claims based on the actions of Dr. Syed. After the statute expired, their experts criticized Dr. Syed. And so the trial court granted summary judgment in favor of Dr. Syed's employer, 24-on, for the claims against it based on his actions.
Well, let me ask you. So, what if they had simply notice pleading? They simply say in their complaint, 24-on is vicariously liable for any of the actions of their nurses or any of the treating physicians, and we're going to flesh all that out in discovery. You know, we don't know everyone, and so what if they had just done that?
Well, Your Honor, it would depend on the facts that are pled as well.
Right.
I mean, with
They're
the
not suing any individual doctors. They're just straight up against 24 and on and saying we're seeking vicarious liability against this entity.
Sure.
And so then they come back. So I guess my question is, if they had done that, is it your contention that either in the complaint or in the corresponding affidavit that they have to name names at that stage?
They do not have to name names. They do have to identify in some manner the facts that are the basis of the professional judgments that are at issue in the claim.
Does that mean, with your answer there, does that mean that if in discovery no names change, same company, 24-on, same doctors, but they discover additional things that the doctor allegedly did that was could constitute malpractice, that they would not be able to rely upon these additional procedures that were performed or not performed to try to prove their case?
So if they
And if that's true, tell me in the statute where it says that, because I don't see it.
Okay. And so I make sure your question to me is that if they had named 24-on for the acts of physicians that they did
Well,
not.
let's just say they named Dr. Syed,
Okay?
but then, and they said he was negligent, and 24 is vicariously responsible for that negligence because he did this.
Okay?
But then during discovery, they discovered there was something else he did that contributed to the injury that was also negligent. And then they wanted to prove those additional allegations, but those allegations weren't included in the affidavit, nor were they included in the complaint. Are they barred from traveling under these new, potential malpractice actions?
No, not if those claims, the additional claims of negligence pertain to the professional who was identified in the complaint in the affidavit. So the statute says that you have to have one specific act of negligence against the defendant. The professional, it doesn't say the words defendant, one specific act of negligence. And what that phrase modifies is the three situations where a professional's judgment can be at issue in a claim.
Let's go back to the statute, okay?
Okay?
The purpose of the statute, as embodied in the terms of the statute, is what? The 9.1 requirement. What's the purpose of
The
that?
purpose of the statute is to screen frivolous lawsuits.
And so, if the purpose is to make sure that there's a valid claim, then why do you bar new claims that come up based upon the discovery of new negligent actors?
The purpose of
Because you still have a valid claim as to the ones that were originally pled.
well, potentially you do. I mean, in this
Well, we have to assume prior to summary judgment that and when you don't file an objection to the 9.1 affidavit that was filed, we have to assume that those claims are valid at least at this stage. So then why would you bar new claims that would be vicariously responsible of your client that may arise through discovery for a new actor when we know that we've got, at least at this point prior to summary judgment, a valid claim?
The purpose of the statute was exactly as you said, to screen out frivolous claims. And what the court held in the Medical Center of Central Georgia case is that each claim against a professional for vicarious liability constitutes a different claim against that corporation. It's a new claim if it's a new professional, and so you need an affidavit within the statute to bring that claim.
But we're talking about the same injury and the same death to the same person, not someone else. And what we're talking about is an additional act that contributed allegedly to that death. So where's the new claim?
The new claim is because these are actions, it's a different professional judgment by a different person. And it was not at all at issue within the statutory period. The factual situation is different. Dr. Syed wasn't making decisions about Ms. Noble's diabetes and how to treat her in order to avoid a hypoglycemic episode. The whole basis of this claim in the beginning was that Dr. Mitchell and Dr. Hunt caused this hypoglycemic episode in this patient by not managing.
But what if you can't find out this information until discovery? And let's say that, I guess what concerns me, it sounds like, and correct me if I'm wrong, it does sound like we're kind of going beyond notice pleading and the gatekeeping function of the affidavit and requiring a lot of specificity up front prior to there even being any discovery. Am I wrong about that?
There is notice required. It's the exact same notice that would be required if the plaintiff had decided to name the individual instead of the corporation. So there's no additional pleading burden. I mean, there's no additional burden here. Plaintiff has the option to name a corporation for the acts of professional liability of its agent or against the agent. And the way the statute is structured is to make sure that no matter which option they choose, there is a 9.1 affidavit filed timely that criticizes the judgment of that professional.
Let's go back to the hypo, because I think you've taken an inconsistent position. I want you to tell me if I'm wrong.
Okay.
Dr. Syed is named as the negligent actor from the very beginning, and it was something, this is one thing that we allege in the complaint that he did wrong. But then during discovery, you determined that there was something totally different that he did that independently would have contributed to the death. the fact that it's the same person seems to be somewhat irrelevant. It's something different. It's a new theory. It's a new action. It's a new, as you use your word, a new professional judgment or lack of judgment. But yet you have conceded that that issue could be litigated because Dr. Syed was named, even though this additional action, which was a different professional judgment, wasn't named. So how is that any different than if it's a totally different person? Given that Dr. Syed is not sued and 24-own is sued and was sued timely.
It's not inconsistent, Your Honor. What the court has done is, and what the law does, is to preserve a balance between notice pleading and the ability to amend a claim. So if a professional is identified as having at least one specific negligent act or omission, which is the requirement under 9.1, if they are identified by doing that within the statutory period, then the statute doesn't run against that professional anymore. And all the cases cited by the plaintiff say you're on notice by that one determination. And so
the statute is important because a defendant has a right to be sued within the terms of the statute, right? The statute of limitations. But in your case, 24-own was sued within the term of the statute or the renewal thereof.
24-on was sued for the actions of Dr. Hunt and Dr. Mitchell within the statute of limitations. They were not sued for the acts of their treating physicians. There was no broad language that preserved.
Wasn't that actually the term that was used in the complaint, treating physician?
The complaint that you saw was that was allegation that related to both Rockdale Medical Center, which is not an issue in this case, in this appeal, as well as 24-on. And it says, and this is in count 1, after all the facts that are pled in this deal with before the time period when Ms. Nobles was found in hypoglycemic shock. They don't talk at all about the time period when she was found, which is when Dr. Syed was involved. And
Are they required to in the complaint?
The affidavit at least is required to set forth the factual basis for the negligent act or omission. The significance of what's in the complaint and the factual pleadings that are within the complaint is whether it would put defendants on notice that potentially this affidavit of Dr. Cooper filed with it is defective. In other words, if I can look at this complaint and see they intended to challenge the judgments of Dr. Syed or of some physician who treated the hypoglycemic episode.
Well, how does the ability to amend your complaint, in your mind, how does all of that enter, before the pretrial order? What's your position on that in relation to the statute of limitations?
Well, there was no amended complaint in this case ever filed.
Right. Could they have?
The plaintiff, they can amend their complaint, but what happened at the Thomas versus Medical Center,
Right.
Central Georgia case, was both an amended complaint and an amended affidavit against a different professional. And the court said, no, that is untimely.
Is that an outlier case? Do you agree with, I take it you do not agree with GTLA that we should overrule Thomas?
I do not agree no, because this court has consistently held that the purpose of 9.1 is there are cases where you can't get in the door with an affidavit of one act of negligence against one professional and preserve claims against other people.
Is
Now,
Thomas your best case?
Thomas versus Medical Center?
Yeah.
Yes, that's the case that's
How many
directly
times has
on
it been cited since it was published?
It's been cited multiple times. I can't tell you the exact
Okay.
number.
So you don't believe it's an outlier case then?
No, Your Honor. It's consistent with the text and the purpose of 911 9.1. And
As reflected by the text, right? The purpose as reflected by the
by
text.
the text of the statute.
Right.
Yes, that's right. It's consistent with the purposes of vicarious liability. Someone's being held liable for the acts of an agent. That agent is a professional. That's how you know 9.1 applies. And so that's required in order to plead the case. the structure as is set up right now by the statute, which is explained in the Medical Center of Central Georgia case, is it still allows for liberal amendment plea. If it just requires one act against one professional against the professional whose conduct is at issue, whether the plaintiff chooses to name the particular individual or whether the plaintiff chooses to name the corporation. That's exactly what Section A requires. As far as amendment of pleadings in a professional judgment case, that is also controlled by 9.1. Section E of 9.1 modifies 15. It limits that. You can only amend an affidavit and have it relate back for statutory purposes within the specific parameters that are set forth in 9.1.
How much information is available at the time these affidavits are filed to the affiant?
Well, they have the medical records, Your Honor, because they have to get a 9.1 affidavit of someone. And in this case, the medical record says Dr. Syed in the orders when he's involved on its face.
Right.
There's no question of a mistake. There's no question they didn't have to name a John Doe, although they could have. They could have just pled 24 on as responsible for the act of the physician who responded to the hypoglycemic event.
So and I'll give you a little more time, and I'll give more time to your opposing counsel. What if you go by the record, the affidavit is crafted to address the medical record, then you get into discovery, and it turns out that some of the notations or some of the notes in the records are actually wrong. And based on that, and we're past the period of statute of limitations, and based on that, that changes the nature of the lawsuit. It changes the nature. It brings in other people, and it possibly brings in other claims. What's your position on that?
Well, the judgments that are at issue, I mean, that's potentially a mistake that could toll the statute or could allow for relation back. But it is rare that in a case there's so much missing that a plaintiff could not identify what caused. The plaintiff has to have some basis to bring the act, some basis to believe that an actor is negligent in the care and treatment for any case. And so I'm not saying they have to identify the specific note, but generally what act of a professional at what time period caused the event that's at issue in the case, yes, that's required by 911.
Okay, do you have any?
I want to ask one more question. So you, in responding to my question a while ago, you said one affidavit has to be filed alleging one negligent act or omission by one professional, and you extrapolate that to say that if it's a different professional, it doesn't apply. But I'm just looking at the text of the statute, and I don't see the one professional word. What I see is, if this is the current version, the plaintiff shall be required to file with the complaint an affidavit of an expert competent to testify, which affidavit shall set forth specifically at least one negligent act or omission claimed to exist and the factual basis for such claim. So how do you then go from that to say for each particular professional?
Well, first of all, that is the holding of the court in Thomas versus Medical Center of Central Georgia.
We're obviously wondering about the viability of Thomas, but
that is consistent with the reading. So that phrase that you just read in the statute, it also doesn't say against one defendant. I mean,
well, it does, because if you go up to the previous provisions where it's talking about the licensed healthcare facility, and we're talking about that defendant, and to that defendant you have to then file the affidavit that sets forth the negligent act, or at least one negligent act or omission that could be attributable to that licensed healthcare facility.
No, Your Honor, what you have to do in any of those cases is set forth the affidavit of an action or inaction of a healthcare professional,
That's
a
correct.
licensed professional, not an act of the facility.
I understand that. We wouldn't even be here if that wasn't the case. But I don't see the text that you are claiming that says you've got to name it as to any professional. You have to name a claim against a professional for which the licensed healthcare facility is responsible. I mean, isn't that what the text says? I mean, if there's some other language or another statute, tell me what it is. But
This is the statute, Your Honor, and this court has also held in the HCA claim that the text of this section applies to each defendant when all of the defendants are professional.
of course, because I think that's inherent in the words, because we're talking about claims against and the defendant we're talking about here, we're talking about 24 ohm. We're also talking about these other doctors as well that were named as defendants, unlike Dr. Syed, who was not named as a defendant.
The reading of this statute to require an affidavit of a professional, only one professional who's an agent against a corporation, and then allow additional acts against that corporation, allows the plaintiff to circumvent the 9.1 requirement by naming a corporation rather than naming the individual at issue.
And that's their right as far as who they sue, correct? They never have to sue the individual.
They do not have to sue the individual. But the reason the statute applies, the reason it even has sections 2 and 3 to Part A, is to make sure that even when a corporation is named, the judgment of the licensed professional that's at issue is screened first by a professional competent to testify about that professional.
For at least one claim.
The one claim as to each professional.
Okay. Well, I don't see those words, but I'll read it again. Thank
All
you.
right. You have any other questions, Judge Roy? Judge Self, do you have any other
I do not.
questions?
Thank you.
All right. Thank
Thank
you
you.
very much, counsel. I'm not sure how much time we went over, but, huh? Okay. So I'm going to give that time to Mr. Penn. So let's add that to the clock. You do not have to use all of it, but I want to be equitable. So, and I will say very quickly, I hope you all noticed that Judge Ray was looking on his phone at Westlaw. If you occasionally see us glancing at our phones, this is the modern age. We're not necessarily on Facebook or Twitter. We are actually looking at Westlaw. So, all right. Go ahead, counsel.
Thank you, Your Honor. Judge Ray, I think you're exactly right, and that is exactly how the statute was designed under 911 9.1. The very first section, Section A, is talking about who the case is brought against. It says alleging professional malpractice against, and then it's 1 and 2. 1 is an individual, a professional, and actually some people argue that a hospital can be considered a professional under 1, but for sake of argument here today, that would be the individual. And then 2 is the entity, a domestic or foreign partnership, corporation, professional corporation, et cetera, et cetera. And then 3, any licensed healthcare facility. So the statute itself easily provides for claims just against the facility itself and not the individuals. And again, I think you touched on the language. It says one act of negligence needs to be set forth in the affidavit. And in a vicarious liability situation where there are multiple employees of a facility, all you have to do is talk about the negligence of one of those individuals, and that meets the statute, the requirements of the statute. Also, Judge Ray, you brought up a question. I wanted to address this with you, the question about what happens in discovery of a medical malpractice case when new things are discovered. After all, that's why we have a discovery period, to learn more about the facts of the case and how they apply in the case. Well, this court has dealt with those exact scenarios, or a number of those kinds of scenarios, in medical malpractice context. Hospital Specialists of Georgia versus Gray, 339 Georgia Appeals, 564. That's a 2016 case. It was authored by Judge Doyle, Chief Judge Doyle. And in that case, when the original case was filed, they sued one doctor, and then it turned out in discovery that doctor didn't have anything to do with the care. It was another doctor. So they amended their complaint, amended the affidavit to add the doctor that was never even identified at the beginning of the case. All of this occurred after the statute of limitations, and that was held to be okay. that fits within our law and that can work. In Jensen versus Engler, that's at 317 Georgia Appeals 879. It's a 2012 case. And in this particular case, it started out as an ordinary negligence case. And they went through discovery, and I believe they were, a year beyond the statute of limitations. And they had also, earlier in the case, fought off a motion to dismiss because the defendant alleged that it was actually a professional negligence case. You needed an affidavit. You didn't file one. They won that. And then a year later, they decided, you know what, it is a professional malpractice case. They amended their complaint, added an affidavit, which some might argue that that's a new claim. It's a year after the statute of limitations, and that was okay in that case. Thomas versus Tenet Health System, 340 Georgia Appeals 70. It's a 2017 case. It was from this January, from this court, where it's the opposite. It started out as a professional negligence case, and then as they got into discovery, they learned about a policy that applied. It was a hospital policy that was applied. They felt like it was a negligent, and they switched to a simple negligence count after the statute of limitations, and it was held to be okay. A couple of other things I wanted to clear up, and I started this in my argument, but if you look at the complaint that was filed within the statute of limitations, that's correct. We never amended the complaint because the appellants didn't have to, because they alleged vicarious liability against 24 on in that complaint, and they used the language that says 24 on by and through the Rockdale nursing staff and the treating physicians as actual and or ostensible agents. It says that throughout this entire count. And it also talks about failure to properly respond to and treat a hypoglycemic episode, which addresses this whole before and after distinction that's been attempted to be made. That simply didn't occur. There were also two other counts in this complaint. Counts 4, which alleges negligence against 24 on and Dr. Hunt, and then count 5, which alleges negligence against 24 on and Dr. Mitchell. If we're only talking about Mitchell and Hunt in this complaint, there's no reason to have count 1. So,
do you agree? I'm sorry, counsel. Do you agree that we have to construe the statutes regarding kind of pleading notice and the affidavit together? In other words, it seems that there would be tension if you're basically requiring the affidavit to lay out every aspect of a medical malpractice claim prior to discovery. Going back to what I was saying earlier, there may be things, if all you have at the time of the affidavit is the record. I mean, I'm sure both parties know things in discovery can show that the record is inaccurate or doesn't give a complete picture of what happened. And so that's my concern is are we basically, these are filed, if not simultaneously, within close to one another, right? I mean, they would have to be filed simultaneously, right?
That's correct.
And so on the one hand, we're saying notice pleading, and it just seems to me like that there has to you get into some tension if you're requiring too much specificity in the affidavit, or am I wrong about that?
I think you're exactly right, and that's why if you look at the number of cases that in discussing this law, repeatedly state that the record needs to be construed in favor of the plaintiff. A. B. The affidavit that is filed has to be construed in favor of the plaintiff, liberally in favor of the plaintiff. Even if you could construe it in another way, a negative way against the plaintiff, you still have to treat it in the most positive light for the plaintiff. And I think that goes hand in hand with our notice pleading requirements. And in fact, the statute 911 9.1 under subsection C provides for this. It says, essentially, if you file an affidavit with your complaint, and then you later amend that affidavit, and it's outside the statute of limitations, the statute of limitations will not be treated as a bar to that additional affidavit. One other thing I wanted to point out as my time expires, is there's this third affidavit that's hardly even mentioned in the briefing, and this third affidavit was filed within the statute of limitation period. And I just wanted to point out before it clearly says in this affidavit, the negligent departure from the standard of care of defendants Rockdale and 24-on physicians is included the following, and it lists two specific deviations from the standard of care for 24-on. So even if we back away from all of this stuff, there was an affidavit filed on the record that specifically implicated 24-on.
Thank you, counsel.
Thank you, Your Honor.
I want to thank both sides for a well-argued case. I want to thank you. The briefs were very well written. I also want to thank the Georgia Association, Georgia Trial Lawyers Association for an excellent amicus brief, as well as the Medical Association of Georgia. This is a very well-briefed case, well-argued case, and I thank you for it. Makes our job easier when we have such great advocates and great advocacy. So thank you very much. Safe travels.